Hello, everyone. This is Brian Jackson. Welcome to another episode of Lawed Up. Hope everyone had a good Thanksgiving. I had a good Thanksgiving. I saw the movie Wicked, and that was good. I'm a fan of that movie. It's a good movie. I guess I'm a backdoor Wicked fan. My only critique is that you can't beat the original Broadway cast by with Idina Menzel and everyone else. So those are hard shoes to step into, but still good movie. Today we're talking about public employee termination hearings. I think this is important because I got a phone call from somebody either last month or a month ago, and they worked for the government. They worked for a government entity, and they called me and they said that they talked to another attorney, and that attorney said, "Oh, you're at will," because he was terminated, and said, "You're at will, so there's nothing you can do about your job." And man, that is a big no-no. So if you have employment questions, it's good to make sure to talk to an employment attorney who knows employment law, because it's not as simple as it's an at-will state, especially when it comes to public employees. So you want to be very careful about that. And there's a lot of employment stuff that is statutory based, and so you just have to know the statutes. And so if you haven't practiced employment law, if that hasn't been your forte, then you may not know all the nuances of all the statutes as it comes to overtime pay, as it comes to discrimination, reasonable accommodations, the Americans with Disabilities Act, Fair Labor Standards Act. There's so many acts out there. And then also there's other parts too that when it relates to public employment as it comes to the Constitution. And so the Constitution comes into play in public employment, and not a lot of attorneys know that. So that's why it's important when you need legal help to go to someone who specializes specifically in that area. And if you're going to a friend, family member who practices a different area of law, you may not get the right advice you need. So, I mean, a lot of people think that, hey, we went to law school and we know everything now. We know all the laws. We are walking legal encyclopedias, and that is not true. I mean, first of all, laws change all the time. Every day, your city is changing new laws all the time. Your county is coming up with new ordinances all the time. Your state is changing laws. And then you have judges. Judges are interpreting law. The judges are striking down law. So the law is always morphing, changes. There's always administrative agencies coming out with new rules, new policies. So we don't know everything. And there's some areas of law that I'm not savvy on, and I have to pass that on to another attorney. I started doing franchise law, and it's a beast of its own. It's very red tape, very regulated by the federal government. And prior to me learning franchise law, if someone had come to me and said, "Hey, I want to draft a franchise agreement," and me not knowing franchise law and just thinking like, "Oh yeah, it's a simple contract, I'll just draft a license agreement for this person, they'll be on their merry way," I would commit some serious malpractice. So, beginning side note, it's important to go to attorneys that specialize if you want to get the correct answer, especially when it comes to employment law. So let's talk public employment law. So if you go to my podcast on the 14th Amendment, you'll learn that under the 14th Amendment, there is language that says no state shall. And, and it talks about talks about equal protection, and it talks about deprivation of life, liberty, property without due process of law. So, as a and so why the 14th Amendment is important, so important, is because it ties states to the federal Constitution. So before that, so this 14th Amendment came out in the 1860s after the Civil War. So before that, technically, if there was a state that didn't have freedom of speech in their own constitution, technically that a state could infringe on its citizens' speech. So it definitely bolstered individual rights, your right to your Fourth Amendment rights, your Fifth Amendment rights to not testify against yourself, your right to an attorney. All of those got bolstered because now all 50 states, are tied to the federal Constitution, and that happened just through time, through Supreme Court cases where the Supreme Court slowly came out and said, yes, this is a fundamental right, due process. You can't deprive someone of their Fourth Amendment. States can't deprive people of the Fourth Amendment. So it's kind of took time, but pretty much they implemented most of the Bill of Rights in those first 13-ish or 8-ish amendments and to the Constitution. So because of that, as a public employee, you have the right, you have a liberty slash and or property interest in your employment, your public employment. There are some nuances, and they've come out with a few kind of exceptions, but that's the general lay of the land. And this is public employees and and state, local government employees. So it doesn't matter if you work for the city or for a county or a parish for Louisiana. If you work for the government, this applies. If you work for a contractor of the government, this probably does not apply. You don't have a public interest. And so the reason why it's different is because of the 14th Amendment. So the 14th Amendment says you cannot deprive someone without due process of law. The government can't. So what the 14th Amendment is it's a restraint on the government. And the Bill of Rights is a restraint on the government, on saying, government, there are things you cannot do without jumping through some hoops, essentially. And so it's not just I have free speech, I can say whatever I want, whenever I want. No, free speech doesn't exist with private companies. If you say whatever you want, they can terminate you, and you can't say, hey, they violated my free speech. It's if the government intrudes on your rights. So a private company is not the government, so when it can intrude on your rights all they want. They can search you without a warrant. They can do whatever they want. They can ask you questions without saying you have a right to an attorney. I mean, they can't do whatever they want, but I mean, they can. There's some things that they can do that the government can't do. And whether or not you're a public employee with a private company depends on how entangled the private company is with the government. So that's government entanglement question. And so there'd have to be analysis there, but it'd probably be hard to claim that a government contractor is an employee is a public employee when they're working for a government contractor. That's probably an uphill battle. So because of that, because they can't deprive you of your employment, which is liberty, property, interest without due process of law, that means you are allowed due process before you are terminated. So like the individual that came to me, He thought he was just out and there was nothing he could do. He thought he was an at will, and at will means I can be terminated for whatever reason. Um, and if it's based off a protected class, well, yeah, I'm out, but that's not true per se. Yes, technically, if you're at will, you can be terminated for whatever reason, but there are exceptions to the at will rule too, which is important. So, like I mentioned, protected class, they can't terminate you based off race, religion, disability, sexual orientation, or any other protected classes. And some states have more protected classes than what the federal government has. Or if they terminate you, if you're a whistleblower, or other protected activity, if you were involved in an investigation, if you testified during one of those investigations, other related things, they can't. So at will doesn't mean they can terminate you for whatever. There's still exceptions to that law. But at will means they can just terminate you and you don't get that due process. They just say, hey, you're out. And if it really was, we're just terminating you and there was no whistleblower, discrimination, protected retaliation stuff, then that's it. Then you have to move on with your life. So in public employment, you get a hearing before you get terminated. And so this all comes from the Supreme Court. The Supreme Court has come out with decisions and said that yes, you have a property liberty interest. And the biggest case that everyone knows that's mentioned is Loudermill. And so when we talk about public employment, we talk hearings, we talk about Loudermill hearings. And that was when a decision where they mentioned that yes, you get due process before your employment can be terminated. And so what does that look like? And what is due process? Because that is vague term. So due process is there has to be some kind of adversary / judicial process that you get to go through before they make a decision to terminate you. And so usually requires putting on being able to, I guess what the Supreme Court has said is very least you are able to review all relevant documents related to your termination. So the government just can't come out and say, hey, we're terminating you and withhold documents. And that's a big issue, can be a big issue with these hearings, is the government intentionally withholding documents from you. So you're entitled to all relevant documents based off the decision to terminate you. And then you're also entitled to cross-examine anyone that was involved in the termination investigation process. So very least, Supreme Court has said that you're allowed to review all relevant documents and you're allowed to cross-examine witnesses. And usually what happens is there's typically 2 hearings. So there's a pre-termination hearing. So you get a pre-termination hearing, and it's a very, very loose hearing. And it's very, very informal. And what it can involve is they say, hey, they have to give you a pre-termination notice and say, hey, we're thinking about terminating you. And that's important too, because also due process requires notice. Say, hey, we are thinking about terminating you based off this, and they have to cite the statute, and then they have to cite the facts and the evidence. And so if you don't get notice either, you don't get a proper notice, that could be a due process violation too. They also have to explain your appeal rights. If they don't explain your appeal rights, that could be a due process violation as well. So a lot of due process issues, but with the pre-termination hearing, so they give you this letter saying, hey, we're thinking about terminating you based off this. And then usually you have a hearing. Sometimes it's with your supervisor, sometimes it's with someone with HR or some higher up. And they sit down, and essentially at that point, you're allowed to give your side of the story and say, hey, well, no, this is what happened or whatever. And so it's very informal. Typically, lawyers aren't involved in that process. They can be. Um, but usually that's not when the lawyers step in at that point, but it can be important, especially if there is, if you're accused of a crime, it's probably important to get an attorney to make sure that you're not going to say anything that can be used against you in a criminal proceeding as well. So Fifth Amendment rights. So probably want an attorney to look at that. Also can be important to have an attorney with pre-termination process just to make sure that due process is adequate, that they're giving you proper notice, that they're giving you all the evidence. And also, I mean, attorneys, what they do is they review the evidence and they analyze. We're analyzers. We look at the evidence and we see what evidence is important and that people need to know, that needs to be highlighted, and to help you in your case, essentially. So a lot of people who don't understand what the burden of proof is, what you need to prove, may not be able to hone in on, hey, these are the most important facts, and these facts aren't as important. So you may be barking up the wrong tree, per se, if you go to pre-termination hearing without an attorney, and maybe talking about facts that really may not be relevant to the case, or at not as important, or not highlighting the other important facts. So that's kind of the pre-termination process. And so after you kind of get to have your say, and you can also bring in documents too at that time, and it's probably important to get all the documents that you have while you still can before they terminate you, because again, like I say, you may have an issue getting those documents down the road. So it's important to make those copies and have them related to whatever, because you might have regrets, like, oh, I wish I was able to pull that, because sometimes it can be like pulling teeth trying to get those documents, and sometimes government just doesn't play fair. So after that, the pre-termination hearing, then they make a determination and they say, hey, based off what we have reviewed, we've decided to not terminate you, or issue a different disciplinary action. And also, if you only get a different disciplinary action, like a written warning or something lower than termination, then your due process rights are lower because they're not depriving you of your employment. And so then basically at that point, you just have to follow the policies and procedures of the government if you want to appeal something lower than termination. But and then with your termination, if they do say, hey, we're going to terminate you, then you get a more formal hearing. And so what that could involve is, it could be the head of your government department, that could be like the judge, or sometimes they call neutral parties like attorneys, administrative law judges, that step in and make a determination, or a board or panel can take a look at it. That's like the higher ups of the government. Um, and but and so at that point, it's more formal, and you're able to call witnesses. And usually how it works is the government should have the burden of proof of proving that, hey, this termination was warranted. And then you typically have the the chance to rebut and say, no, it's not warranted. And you can call your own witnesses, you can put on your own evidence. And so, yeah, it's like a mini trial, essentially. Usually, the rules of evidence are a little more loose, though. There's a lot of stuff that can come in that may not be able to come in at a formal trial with a judge, like hearsay. You can't. So hearsay, what it is statements that are made out of court. And there's a lot of exceptions to hearsay, but you have to walk on eggshells when it comes to hearsay at a trial. But at a more formal level, there is a lot of hearsay can come in. There could be some reasons why, but it's pretty much fair game. And a lot of documents, it's easier to get documents in. And I mean, that I'm not a fan of it because sometimes it's just not clear what the rules are and what can and can't come in, and that can make it not fair where, administrative law judge says, hey, this can come in, but then doesn't allow other evidence to come in, even though they allow the other evidence to come in kind of on the same grounds. And so my problem with it is there's no clear rules on evidence. Maybe there's some states or government agencies that do have more clear rules, but the ones I've dealt with haven't. And so, yeah, it's kind of a unknown on what rules of evidence these judges or hearing officers are going to latch on to. The other issue is if you do have, if your decision maker, kind of judge person, isn't an attorney and they don't have a legal background, there could be a lot of stuff that's over their head that could be really important in an attorney's mind. Like, oh man, this is a blatant violation. Like they withheld this document, or they didn't let me cross-examine this witness, or they didn't properly apply this legal standard, or they didn't even use the proper facts. Without having legal training, that could be over their head. So a lot of times you could be at a disadvantage just because of that, because your hearing officer may not have that legal background. But it's definitely a good idea to lawyer up, especially if you think it's unfair, and have that due process right. So I mean, a lot of it depends on if you really thought it was unfair and you think you're being picked on and there's an ulterior motive. But even if you think you're dead in the water, it may be good to just have an attorney look at it, because there could still be some due process issues, like proper notice. Maybe they don't have the proper evidence. Maybe they illegally got evidence somehow. Or maybe there's some evidence that you don't know about that you need an attorney to help you get and learn about. So that's pretty much how a Loudermill hearing works. And also, kind of a side note too, is this kind of relates to Loudermill too. I mean, there's a lot of protections on governments, and it's really hard to sue the government. And there's statutes that governments put out say you can't sue us based off this. And one of them is typically defamation. And the purpose of this is we don't want the government to get bogged down with all these crazy lawsuits. We want them to have some kind of autonomy to make decisions and without fear of getting sued all the time. And so usually there's statutes that say you can't sue the government for defamation. And defamation is somebody saying something that's false, that impugns your character, that lowers your character, and causes damages. So like in the employment section, typically you get terminated because of the false statement. So usually governments say, well, you can't sue us for defamation. So if somebody comes out and says something about you and it's false in the government, there is also a way for you, there's also a due process related to that as well. Um, and it's essentially, you have to, if you're terminated, you have to have the chance to clear your name too. So so it's not just you get to process, you have to have the chance to a name clearing hearing prior to them coming out to anything that stigmatizes your character. So it's not necessarily like I have a claim against you, against the government, if you stigmatized my character. It's if they do stigmatize your character, then you have to get a chance to clear your name. And if you get that chance, then great. Then there's no harm, no foul. Essentially, is what they say. Even if it's pretty egregious what happened. But also, that has to be made before the statement comes out, essentially, or anything is publicized. So if the government comes out and says that, hey, this person, committed fraud or whatever, and went to the press and said this person committed fraud, and they came out with that statement before you had the chance to clear your name, then you could say, hey, I didn't have the chance to clear my name. What happened here? So that could be a name clearing violation. But also, typically they say that it has to be published. And so it has to be, or highly publicized. So it typically has to be something that is made to the press or is widely known. So if it's something that just your supervisor told to someone else, that may not be sufficient to say that, hey, I should have been able to clear my name before that statement was made. And yeah, so usually it has to be something that goes on social media, goes out in the press, or if it's made to another government department, that could be sufficient too. So if it's not just from a supervisor to another employee inter-department, but if it goes to another government department, that could be sufficient as well. Or if it's, it could depend on who they tell it to, too. If they just tell it to a third party, but if it's someone who thereafter publicizes it, that could be an issue too. So you also get a name clearing hearing as a public employee. And I guess just from a lawyer's perspective, dealing with these public employment stuff, I mean, the one thing that I've found and seen is that because you're a public employee, it means you have to be terminated for cause. There has to be a reason for them to terminate you. They can't just say terminating you at will, unless there's some other circumstances like budgetary issues, or the position is just no longer needed. Obviously, the government can't just waste money and have their hands tied and say, no, we can only terminate this person. So there could be circumstances, but also, I mean, if it's under the guise of we just want to avoid this termination process, that could be an issue too. And so you still have appeal rights too, should have appeal rights of if they try and terminate your position or say, hey, we don't have a budget for this, you can appeal it and say, I don't think you're correct. I think there is a budget for this, or I think that this was under the guise of termination. But what I've seen is that because you have more rights, it can also create more drama in the workplace. So it's a double-edged sword because, humans are humans. And if you have a supervisor that just for whatever reason doesn't like you and they just want you gone, then they have to come up with a reason to terminate you. So that's where that can create drama in government employment that you may not see in private employment, where you might have a supervisor that is making your life miserable and just micromanaging you and finding nitpicky things on, hey, well, you didn't turn this on time, and then give you a written warning, and then something else comes up and says, hey, you didn't turn this on time, and then give you a second written warning, and then say you didn't turn this on time, and then termination, and could be some arbitrary stuff going on there, and they may not be treating other employees the same way, and you can just tell that they're just out to get you. So that's the downside that I see to that, is that humans may just find a way to terminate you, and it could make your life miserable, which isn't fair, and it's hard dealing with those types of cases, because you have to nitpick every single decision the supervisor makes, and maybe on its face, and just if you read it on paper, it sounds legit, like, oh yeah, you didn't turn this report on time, what were you thinking? But then if you get into the facts of the matter, and you hear the employee's side of the story, you can be like, oh yeah, this wasn't a big deal, or no, you told this person that it was due on this date, or you didn't, well, how come you didn't give the other employees who had the same due date this written reprimand? You didn't do anything to them. And so it's hard, and you have to delve into the facts, and it's hard to switch that stigma and say, no, there's an ulterior motive here. And sometimes, just because of how nuanced it is, it can be hard to overcome that stigma. But I mean, from my experience, most, like, in order to get unemployment in a lot of states, you have to be terminated for cause. And as it comes to unemployment benefits, usually unemployment law judges are willing to give you the benefit of the doubt, and they're usually good at reading between the lines on, really, was this legitimate termination, and they typically lean towards the employee on, hey, no, this really wasn't a just termination. They weren't actually terminated for cause. So that's a good thing as it comes to unemployment. So that's a good thing for people to know, that, oh, well, I was terminated for cause, I can't file for unemployment, or maybe at the initial onset when you filed for unemployment, the administrative agency for unemployment came out and said, no, we're denying your unemployment, and that could just be because the government agency gave those reasons, and you didn't really get a chance to explain yourself. And so it could be a very good thing, and I advocate for this. I mean, it's probably not with this one. I mean, because you've lost your job and maybe you don't have money, and it's kind of tick-tacky on whether or not you should get an attorney, because if you get an attorney, you might end up paying that attorney everything you would have gotten in unemployment. But it could depend too on how long you will be unemployed. So if you're unemployed for 3 to 4 weeks, it may not be worth it. But if you are out 3 to 4 months, it may be worth it to get an attorney to make sure that you get those unemployment benefits, because if you don't, then that would hurt you a lot more financially. But yeah, I don't do a lot of unemployment hearings, and a lot of times I counsel individuals, if they don't even have a lot of money from the get-go, to maybe I can just give them some pointers on how to go through the hearing, what to say, what to focus on, so at least they have some legal guidance, but they don't have to pay for an attorney for a full-on hearing, because you don't know how long the hearings can go. Sometimes they don't take long, but again, like the scenario that I just talked about, when you're talking about so many different situations, and having to go through the verbal warning, the written warning, the second written warning, and having to go through each one, that can take a lot of time to flesh out all those facts. And so it can be a hearing that could last 2 hours, even more because of that. And also, with my unemployment agency, usually the LA judges are the ones asking the questions. So they ask, they hammer the government. They ask a bunch of questions, and then they hammer the employee and ask them a bunch of questions. And so usually the ALA judges do a lot of the heavy lifting anyway. And I find myself a lot of times where I, um, I, I mean, they give attorneys the chance to ask questions as well, but a lot of times they go after me and say, "Hey, well, I already asked that. I already went over that," or and they object to my questioning. And so there, a lot of times I find that in those hearings, there's not a whole lot that I can add to as an attorney. Probably the most important thing I could potentially do is ask important questions. And so if the judge is already covering those important questions, then the only thing I could do is just closing argument, or maybe just nitpicky pointing out a few things. But because of how they cover it, again, it's probably not worth it to hire an attorney full on. But also, I don't want to advocate for that. And I would say that it's a case by case basis. So it's at least worth it to talk to an attorney and see what their thoughts are, and see if they're maybe good to at least get some pointers on your hearing, and point you in the right direction, and let you know what you need to focus on, what the legal standard is, so you can give a proper response at your unemployment hearing. So that's what I got on public employment for now. If you have any questions on public employment, in addition to what I've already spoke about, feel free to put those in the comments. And also remember to like and subscribe. Get more um, get more topics on the law from our podcast, Law Up. Thanks for listening. We'll talk to you next time.